71 years ago today, on July 17th, Korea proclaimed its constitution, laying the groundwork for the nation's democracy. Marking the day, various ceremonies were held across the country, and this year's Constitution Day is all the more special as it marks the 100th year since the establishment of Korea's provisional government as well. Today, we go in depth on the significance of the day and also take a look at the ongoing Seoul-Tokyo trade spat from a legal perspective. For that, Dr. Keechang, professor of law at Korea University Law School, joins me in the studio. It's good to have you with us.
Hi.
You must, as a law professor, you must have a special feeling towards this day. Could you start us off by telling us about the significance of Constitution Day?
Yes. The current constitution dates back from the constitution which was enacted in 1948. But as you mentioned, this year it's 100th anniversary from the provisional government in 1919. So actually the basic framework for the South Korean constitution was in fact based on the interim or provisional constitution which was enacted in 1919. So that's a great sense of continuity. But we have a basic elements of presidential system and separation of powers, all of them, as well as basic human rights, all these Bill of Rights provisions, all built into our constitution.
Now, since the birth of Korea's constitution, Korea has witnessed 9 constitutional amendments. And of the 9, most were related to power structure reforms. And the necessity of a constitutional reform is also being raised at the National Assembly today. Does Korea need a reform now?
I think it would depend on which political faction you sympathize with. For me, I don't think there is any major issues with the current Korean constitution. Some people argue that perhaps the presidential system might need some significant modification, or should we adopt this parliamentary system? I don't think the presidential system has caused much issue. It was rather the individual presidents who might have been the causes of the problem. I don't think it's the system itself. Maybe one aspect which perhaps can be improved upon is the fact that currently the presidential term is 5 years, and the members of National Assembly, their term is 4 years. So the terms are staggering, and that creates a government which cannot have the majority support from National Assembly. So as we are experiencing now, that can, in my view, be improved by introducing constitutional reform. But otherwise, I think the Constitution works fine. Most of all, what is really important is not so much the text, but how it is actually being implemented. We have 2 important institutions. One is Constitutional Court, and the other is National Human Rights Commission. Now, these 2 institutions have done a brilliant job. Constitutional Court have rendered a number of very important decisions, and also there has been impeachment as well. Constitutional Court have played a very important role on 2 occasions. And then Human Rights Commission, although they don't have any binding power about their decisions or recommendations, the Human Rights Commission only has soft power, but it has done a very, very influential role. And these 2 institutions' work is, in my view, regarded with high esteem.
So all in all, Korea's constitution works fine, but if improvements can be made, it should be made in terms of the presidency.
Yes, the term of the presidency. I think it would be better to change it to coincide with the term of the members of the National Assembly.
Now to the issue of the Korea-Japan trade friction, which all began from a historical issue, and that is the issue of compensation for victims of wartime forced labor. Japan is apparently forging ahead with its export curbs against South Korea in retaliation to Korea's Supreme Court's ruling last year, which ruled in favor of the victims. Is it legitimate, though, for another nation to protest against one nation's Supreme Court ruling?
It's a very complex issue, and of course we have Supreme Court's ruling, and the executive branch obviously cannot meddle with the Supreme Court's ruling. But then it's also true that law does not exist in a vacuum. So it is a legitimate causes for concern and a lot of frictions, and the current situation is clearly a situation which requires a diplomatic solution. The root cause of this dispute, in my view, are twofold. One is the question of apology, a very emotional issue. What the Japanese have done, over the past more than 100 years of the colonization, and then what they did towards the end of the Second World War, and then the question of compensation. Now, on those two issues, the problem is very, very complicated. About the apology, I have to point out that Japan has never officially recognized its responsibility or its fault in a formal diplomatic documents. For instance, when Japan normalized relationship with China in 1972, the two governments' joint communique itself contained a Japanese recognition and admission of fault and responsibility about the harms caused to Chinese. With the relationship with Korea, Japan has never done that. Important persons or political figures or even the emperor said some sort of apology, but then soon another equally important politician or members of the government said something which basically overturned what was said earlier. So that's the complicated area of apology. About the question of compensation, we have a very, very complex legal problem how to interpret the 1965 claims agreement. Yeah, that's a very complex area.
So as for the apology of Japan, Japan did apologize to South Korea and South Korean victims, but it never came in a written form.
Never in the official diplomatic documents, never. Because in 1965, when Japan and South Korea normalized the relationship, neither in the basic treaty nor in the claims agreement is there any admission of fault or responsibility. That, in fact, was one of the important legal reasons for the South Korean Supreme Court to rule that claims which is premised upon Japanese admission of wrongdoing was never covered in the 1965 claims agreement. 1965 claims agreement only covered the claims which does not involve Japanese side's admission of fault. Like if you worked and you didn't get your proper wage and you are entitled to claim, but that is not the same as Japan admitting, dragging young women to this sexual service or forcibly dragging Korean people to do slave labor. That kind of problem was never put on the table during the negotiation for the 1965 agreements. So this question of apology and the question of compensation, the scope of 1965 claims agreement, does it cover the current claims which were brought by the victims? The victims are not seeking for the unpaid wages. because they admit that unpaid wages were already covered in 1965. What they are claiming is the compensation for pain and suffering caused by wrongful and illegal behaviors, which Japan never admitted. So the question of apology and the question of compensation, these two are intricately interconnected.
Now, another sticking point about the 1965 Seoul-Tokyo Accord is whether it has the legal force to dissolve individual right of claim.
That is very, very important question, but also very interesting point, because it was actually South Korean government who proposed a language during the negotiation for the 1965 claims agreement. South Korean government proposed a language which proposed to stipulate that claims of both sides against the other country's government or the other country's individuals, both sides' claims shall be extinguished. That's the language South Korea proposed. Japan refused. They wanted to maintain claims of individuals in 1965 because during the colonial rule, a lot of Japanese individuals and companies have had properties, huge and vast amount of properties in South Korea and in North Korea. Now, if Japanese government agrees with South Korean government extinguishing these Japanese individuals' property rights or claims, then Japanese government feared that those Japanese individuals would sue for compensation against Japanese government. So the Japanese government did not want to deal with compensation claims from Japanese nationals. So they proposed that we should not deal with extinction of individuals' claims. So both governments, in the end, agreed not to extinguish individual claims. Instead, they chose a language which is very vague. The language was all problems relating to claims are hereby resolved. So that's the language. But the background is that South Korean government proposed extinction of claims. Japanese government refused to adopt or agree to any of the language which can be interpreted as putting an end to individuals' claims. After 1965, Japanese ministers or even prime ministers repeatedly and consistently answered to the questions from Japanese National Assembly that 1965 claims agreement did not extinguish individuals' claims. So that's the Japanese government's consistent position until early 2000.
Now, Japan is asking to form a third-party arbitration panel that can look into the issue of wartime forced labor compensation. And Korea has to give a response by the 18th. That's tomorrow. But South Korea has not accepted the request so far and is unlikely to in the near future. Why?
The relevant provision in the 1965 claims agreement requires, first of all, a diplomatic resolution of disputes. So I understand that South Korean government position is that we have not even gone through the diplomatic resolution, or at least we have to attempt to resolve the disputes or differences through diplomatic avenue. Only when diplomatic avenue has been exhausted without any results can the arbitration be started. So that's one issue. And secondly, even when arbitration clause becomes applicable, the current arbitration-related clause does not really have any enforceable aspect to it if one party does not choose to appoint arbitrator or does not choose to appoint members of the arbitration committee. So South Korean government's interpretation would be the arbitration is based on entirely voluntary cooperation between two governments. One government cannot unilaterally impose upon the other government the arbitration procedure. But I think ultimately, in my view, the difference is between the current Abe administration and the previous Japanese administration. That's where the difference lies, I think, because the South Korean position and South Korean Supreme Court's position are completely in line with the Japanese court's position and the Japanese previous government's consistent position. So I don't see where is the difference, because even Japanese court, in their repeated cases and repeated rulings, Japanese courts recognize that Koreans' claims against Japanese government or Japanese companies are extinguished only in Japan, only in accordance with Japanese domestic legislation. That is the Japanese court's position, which obviously implies that these claims are not dealt with because Japanese domestic legislation does not apply to South Korea. You know, these two are two different countries. We are no longer a colony of Japan. And South Korean government has never introduced any legislation extinguishing Koreans' claims against Japanese. Japanese, however, did introduce their domestic legislation extinguishing Koreans' claims against Japanese. And Japanese court held that that Japanese domestic legislation, not the 1965 agreement, but the Japanese domestic legislation is the reason why Koreans' claims are not pursuable in Japan. So I don't think the South Korean government's position and Japanese court's position, there is any meaningful difference. And I don't think South Korean government's current position and Japanese government's previous consistent position, which have been held for over 30 years, I don't think there is any meaningful difference. It's only the current Abe government who has completely different view with its own previous governments. So I don't think that it is a bona fide dispute between two governments. It's really Abe government who has to deal with the difference with the previous governments.
Well, it's no secret that Abe certainly has the upcoming upper house election in mind. Thank you so much, Dr. Kim, for your thorough analysis tonight.
My pleasure.
And that does it for this edition of News in Depth from all of us here at Arirang. Thank you for watching.